Hello, everybody. My name is Saad. I am an attorney here in Naples. I'm a member of the Legal Resources Committee, have been for about the past 10 years, and I'm looking forward to showing you our changes from 2024 today here with attorney Kevin Lotus.
Hi, my name is Kevin Lotus. I'm an attorney here in Naples with my own law firm, Lotus Law Group. I'm a board certified real estate lawyer, and I've served on the Legal Resources Committee for 23 years and hope to be able to impart lots of good information about the changes to the contract.
Today, we're going to talk about the 2024 contract changes. We're going to touch on the addendum to sales contract condominium, which is a brand new form. We'll talk about the new required flood disclosure. We're going to talk about the changes to the sales contract. Then we're going to touch on the new allergenic mold addendum and the changes to the cooperative addendum. So we'll switch back and forth between us, and we look forward to giving you this new information. We're going to start right off, as you can see on your screen, with the addendum to sales contract condominium. Again, this is a brand new form. For those of you that are practicing with the Naples forms for some time, you probably are going to be a little surprised to see that standard I of your sales contract has been almost entirely deleted and replaced with a moniker that says, use the addendum to sales contract condominium. So whenever you sell a condominium and you use a NABOR form, please be advised that you must use what you see on your screen, which is the addendum to sales contract condominium. And we've included in red here an admonishment that you need to use this addendum, or you could have a voidable contract. That is, your buyer can void the contract prior to closing if this addendum is not attached to your sales contract. And it's what you're used to at the beginning from a NABOR form. You put your seller information, you put your buyer name and information, and you put the address of the property. And then we get into the details, the meat of the form. You'll notice this property includes the unit being purchased and an undivided interest in the common elements and the pertinent limited common elements of the unit as determined by the declaration. So what you're selling is the unit. Obviously, you're not selling the entire condominium development, and that the property is subject to the rules and regulations of condominium associations under Chapter 718 of Florida statutes. You'll hear me refer to Chapter 718 a couple of times in this form because they've added several new disclosures. And I'll tell you right off the bat, if it's in bold and all caps on this form, it's cut and paste from the statute and it cannot be changed. So just keep that in mind that as we created this form, we had the limitations of the statute, and we did our best to make a clear and concise form, and we'll talk about a slight glitch in the statute as we go through this process. But going forward here, you have now 9 documents instead of the old 6 or 7 documents that you had to produce for the any sale of a condominium. You have the declaration of condominium, the articles of incorporation of the association, the bylaws and rules of the association, the annual financial statement and annual budget of the association, a copy of the inspector prepared summary of the new milestone inspection reports, and we'll talk about those a little bit as we get through this form, the association's most recent structural integrity reserve study, or a statement that the study has not been complete, and we're going to talk about those in greater detail as well. And then a copy of the inspection report provided in 718-301P, which of course is the turnover report for new condominiums after July 1 of 2023, which, just to add a little confusion, those turnover inspection reports can include a structural integrity reserve study, which is different than the structural integrity reserve study that you need to provide as a part of this document. So the legislature didn't do us a whole lot of favors, but as we go through this, I think you'll see these documents are extremely important to maintaining a condominium. Additionally, you'll provide the frequently asked questions and answers form, which is a form you're used to, and the governance form promulgated by the Florida divisions of condominiums, timeshares, and mobile homes, which you're used to seeing in the old forms as the governance form. Make sure you use the latest version of the governance form, which is available in your forms files, Form Simplicity, and other app files that you would use. Okay, so buyer requests that the current copy of these association documents, we refer to all those documents as association documents, be provided at the seller's expense. So note, and it's actually in the statute, that the seller shall provide these documents. So this is a seller expense to provide. I'll say one thing about seller expenses here. The association, if the condominium has more than 25 units, is now required to put these documents as they become available on their website, and your seller should have access to those. So just be advised that the seller does need to provide the documents at their own expense, but they shouldn't cost the seller anything because the association is required to provide them to the seller on their website if there are more than 25 units in the association. Okay. So going forward, now this next portion here, you're used to seeing this. This was cut and paste out of the old NABOR contract from 2022 revisions, and it is the old statutory requirement that you provide, again, the articles of incorporation, the bylaws, the declaration of condominium, the frequently asked questions, and those documents. This is the original requirement that they be provided. And if they're not provided, then of course there is the 3-day right to void the contract by the buyer. And that we include in that the governance form, which also, if not provided, the buyer has 3 days to void the contract after receipt of all these forms. So you're used to that if you've done this before. The real new meat of this addendum, and the reason we created it, starts here at the bottom of page 1. You'll notice again that this is all in bold and all caps because it is required by statute. There are 6 questions that your seller has to answer and provide to the buyer, or the buyer can terminate the contract. First off, the association is or is not required to have a milestone inspection as described in the statute. If the association is required to have a milestone inspection, the association has or has not had the milestone inspection. So you need to get the information from the seller. And of course, I think Kevin will agree with me, a best practice here is to have the seller prepare the condominium addendum and put it in MLS so that the buyer can download the form and sign it as a part of their offer.
Absolutely.
Yeah, I think that that's a great way for you to get your listings sold faster and simpler and avoid that 3-day right to void the contract after the contract has been signed. And just to add clarity to that, once you sign the contract, the buyer has 3 days to void the contract, no matter what. But if you delay in getting these documents and these checkboxes done, the buyer has 3 days after it is complete to void the contract. The next question you have to answer, the association is or is not required to have a structural integrity reserve study. Now, the structural integrity reserve study and the milestone inspection reports all have different dates when they have to be done, but essentially by the end of 2026, pretty much every condo that's older than 25 years old is going to have, or 30 years old, is going to have a milestone inspection and a structural integrity reserve study. Again, if the association is required to have a reserve study, you need to notify them whether it has or has not been completed. And then same thing with the turnover inspection report. For new condominiums after July 1 of 2023, is the association required to have a turnover inspection report or not, which they are, and you check the box for is or is not here. And then if the association has, where is it? If the association is required to have one, have they completed the turnover report? So these are the 6 questions that have to be answered. Or again, the buyer has the right to void the contract. You get this information from your management company. If the structural integrity reserve study or the milestone inspection or the turnover inspection report are not completed, then you need to get into the dates and figure out whether they're supposed to have been completed. And now I will say this, we had a long discussion of legal resources and we kind of read through the statute, and we determined as long as you make these disclosures and they are accurate, even if for example, the milestone inspection report is to be done, but it's not done, as long as you make the appropriate disclosure, then the buyer would not have a right to void the contract. So it's important that these disclosures be made and be made accurately. It's secondary whether the reports have actually been prepared. Okay, so we have a fairly confusing statutory requirement here. I'll pause and ask if anybody knows the governor or the legislature, give them a call, let them know we have a glitch in the bill. Your new chapter 718-503 statute has an and where it should have an or. So in our wisdom as the Legal Resources Committee, we put both disclosures as required by statute for the milestone inspections and the structural integrity reserve study and the turnover inspection reports. We put both disclosures in the contract and gave you the checkbox here or here where you need to determine whether the reports have been provided already, and then check the appropriate box. Box A says the buyer hereby acknowledges the buyer has been provided a current copy of the reports. Or box B, this agreement is voidable until the reports have been delivered. So again, if you check the appropriate box and you make the appropriate disclosure, then you can avoid the voidability issue. If you check the incorrect box, for example, if the reports have not been provided to the buyer, but you check box A saying that they have been, there is case law in Florida, and Kevin and I have discussed it before, that says even if you say they've been provided, if they have actually not been provided, the buyer has a 3-day right to void the contract. So be very careful about which box that you check here. Again, and we put it in bold, select only one box. Don't check both boxes. If the association has completed the inspection reports, then you make the following disclosures. And we did put a default. If you fail to check a box, then box B will apply and there will be a 3-day right to void the contract. Okay, up next, the legislature also created a new disclosure for multi-parcel buildings. Now, I will tell you that, again, at Legal Resources, we looked at this from a practical standpoint, and it does not appear really that there are any multi-parcel buildings in Collier County yet, although I'm sure that there will be some in the near future. A multi-parcel building you might think of as a condominium tower that also contains office space that is not part of the association, or a hotel or retail or something of that nature that is not a part of the association. That's a multi-parcel building. If there is a multi-parcel building and you are using the NABOR form to sell a condominium unit in that building, this is the disclosure that is made and you're all set. There are no check boxes. The disclosure is made and the buyer is aware, and you can proceed with your closing. We added a few additional points into the condominium rider that we thought were very, very important. First is the right of first refusal here. If the association or the membership has a right of first refusal to buy the condominium that you're trying to sell, then the seller has 5 days, what has to happen is the seller needs to inform the association of their contract as pursuant to their declaration. And then the seller has 5 days after receiving the association's decision to exercise or not to exercise the right of first refusal to let the buyer know that the transaction is proceeding forward or terminating. And again, if the association or the membership of the association exercises the right of first refusal, then the contract terminates and the buyer's deposit goes back to the buyer. Up next, the hazard insurance. So many of us in this new post-pandemic, post-hurricane era are seeing issues where with the new Fannie Mae, Freddie Mac condominium questionnaires and the post Surfside addendum to the questionnaire that relates to insurance. So we put a provision in this new rider, this new addendum, that says that the seller shall provide, that means they have to do it, a copy of all insurance policies covering the property and the association, and the buyers advise that their lender may require those as well. Up next, we put a notice in here that has always sort of been assumed, but now it's very clear in the contract that any annual assessments levied by the association, rent on recreational fees, if any, shall be made current by the seller at closing, and the buyer reimburses the seller for all prepayments. Those are your prorations. And the seller shall pay all fines against the association at closing if the seller has outstanding and delinquent fines. And then we put a statutory advisory note. This comes out of Florida statute that the listing and buying broker are not responsible for errors or inaccuracies contained in the association documents. Those again are those 9 documents that you need to provide as the listing agent to the buyer. Then buyer and seller sign the contract, sign the addendum, and date it as you've always done. Now, below the signature line, not included in the contract, but available for the buyer's reference, is some new information that has been asked by the membership to be provided for many, many years. And so we finally have decided that it needed to be put into the form. And this is the fee disclosure, as you can see on your screen. The following information is provided for buyer's reference. It is not warranted by seller or broker. It is not required by statute. Buyer must verify the accuracy of the information below by referring to the association documents. And we provide space for the seller to give the current association fees, assessment, and other association charges as follows. And then you would fill in the amount, the frequency, and who the check goes to. And you have 4 spaces to fill those in. Depending on your association, you may need 1 or more of those spaces. And then lastly, we have provided an opportunity for the seller to give the association and management contact information to the buyer so that they can make application. Now, in the sales contract, as we're going to talk about in a few minutes, you will see that it is the seller's obligation now to provide all of this information for application, but we provided in the condo rider addendum blanks to get the contact information over to the buyer. And then we provided admonishment to the buyer that the buyer may need to do additional investigation into all of the various issues that come with home ownership, foreclosure, insurance, budget reserve, delinquent assessments, ownership, financial information, membership in the clubs and other amenities and things like that, that would go with owning the condominium. And again, it's on the buyer to provide that, to research that information. And with that, I will ask my esteemed colleague, do you have any comments, Kevin?
I don't, other than just be aware that this is a very different procedure than what was done with the NABOR contract before, in that if you had a condominium before as being the subject of your transaction, there was not a required condominium addendum that needed to be added. And this is really the red language at the top of the first page. It is now required for use with a NABOR contract. Understand that if you have a new a new contract for a condominium and this document is not used, then under Chapter 713, the buyer has the right at any time and for any reason to terminate and void the contract. And of course,
718, I think we mean. Yeah,
718, correct. Where before you would attach a separate rider for a condo with like a FAR bar contract, now you must use the NABOR condominium addendum if you've got a condominium under a NABOR contract.
And with that, I'm now going to switch us over to the sales contract. We're going to walk through the changes to that. Give me 30 seconds.
While Sam's pulling that up, one thing to keep in mind, obviously, you always want to be using current versions of the NABOR forms, and you will know that they are the current versions of the NABOR forms because at the bottom of each page for the copyright date, it'll say NABOR 1/1 of 2025. If you've got an earlier date on your contract that you're putting together, you're using an older version of the contract, and you should be using the current version. Also, there is a recent NABOR magazine article that covers, in summary, the changes to the sales contract that you can refer to later. But what we're going to do now is walk through the specific changes that were made to the sales contract so that you can be aware of them. Of course, we're looking at a highlighted, redlighted version of that here. But to outline it, at the top of the first page, you'll notice in the list of the items that are included in the transaction, if they are in the home or a part of the home, you'll notice the inclusion of solar panels and related equipment. Those are now specifically included in the transaction. Obviously, they can be excluded, just like anything else can be excluded, by listing that item to be excluded on line, what would be line 18 of this. But note that the solar panels and related equipment are now included in the transaction. Also, on what's line 26 of the red line, there was a little bit of prior confusion. This is where we're identifying the seller's conveyance of their exclusive right to use certain parking spaces, garages, cabanas, storage lockers, or boat docks and slips. The word identified has been added there. The key there being is that if there are two parking spaces, if you're getting spaces 70 and 71, what you're going to be putting for those parking spaces in that blank is 70 and 71, not the quantity, which might be two. You want to specify the particular identified parking space, garage, cabana, storage locker, boat slip, or boat dock. Also, on what is lines 34 and 35 of the red line, this is a minor change, but it's an important change. The deadline for the payment of the additional deposit, the second deposit that's made under the contract, many contracts will have a second deposit. There's no requirement that there be under the law a second deposit, but Most contracts here have a small initial deposit and a more substantial additional deposit. Previously, there was the blank there to indicate the number of days after the effective date that additional deposit came due. However, if that was not filled in under the old contract, technically that second deposit didn't come due until closing because the number of days wasn't ever specified. So now there's a default there that if you don't put a number of days in line 34, that it defaults to the second deposit being due 15 days after the effective date.
And don't forget that many buyers have qualms about putting a second deposit down until their inspection is done. So if your inspections are going to take longer than 15 days, which of course is the original default in the contract and remains the default today, then you need to adjust this date. Otherwise, your buyer is going to make a deposit in the middle of their inspections.
Right.
And then, Kevin, don't forget, we also added a default for the initial deposit.
No, that actually was there before.
It was added, yes, it was added early on. And I should tell everyone, should have mentioned at the beginning, these changes are all the changes between the 2022 and 2024 forms. There were a couple of updates along the way. And so this red line that you're looking at actually incorporates all of the changes over the last 2 years as kind of a comprehensive update.
Right.
And Kevin, you want to mention the dates again?
Just again, the initial deposit defaults to a 3-day period.
Oh, I'm talking about the copyright.
Be looking at the bottom of each page to make sure that you're using the current version of the NABOR forms. They will have that 1/1/2025 date. If the form that you're working on has an earlier date, you want to discard that and write your contract on the new forms. The next change is in paragraph 6, or actually in paragraph 3, excuse me, relating to the reference there. Yep. And it merely isn't really intended to clarify that as of the closing, that the seller is obligated to vacate and give access and possession of the property. We're going to talk a little bit about a related issue when we get into the change in standard R. But again, this is clarifies that access and possession transfers at closing. And again, we'll come back to a corollary issue to that. The next change, that's just really kind of clean up. The state.
I always point out that we just deleted the Equal Credit Opportunity Act language and just a statement from the lender during the finance period that says that the buyer cannot get financing is good enough for the buyer to terminate. Yeah.
That's right. That's right.
And then paragraph 6. Yeah.
Yeah. And then the next one is in paragraph 6. And this is a change that a lot of people had been asking for. Of course, you've got the base rule in the first sentence, what I call the base rule, the general rule at the beginning of paragraph 6, which says that with respect to association, special assessments, and governmentally imposed liens or special assessments other than CDD MSTU assessments, which are addressed elsewhere in the contract, that the seller is obligated to pay the full amount of those which on or before the effective date are a lien or special assessment that is certain as to the identity of the lienor, the property subject to the lien or special assessment, and the amount of the lien or special assessment. A good way to think about that, in my view, just as a practice pointer, is when you're looking at that kind of special assessment, you're looking at have all the votes taken place to enact that special assessment. And if the answer is yes, that means there's no more votes that have to occur, no more approvals by the board or by the membership that have to occur. And the amount of the assessment is certain. It can't be something vague. It has to be concrete. So the general rule is that sentence, the first sentence that said, which really is substantially unchanged, that the seller pays the full amount of that special assessment, which is full and final and certain and enacted on or prior to the effective date. However, this next sentence, the one that's underlined here, creates a special option here. It says that notwithstanding the above, so notwithstanding that rule we just covered, if a special assessment is levied as of the effective date, meaning it's levied, it's in effect, all the votes and approvals have taken place, the amount is certain. But if the special assessment is levied as of the effective date, and if it may be paid in installments, it gives you the opportunity on line 97 to check which party, whether the buyer or the seller, and if you leave it blank, then it defaults to the seller, pays all of the installments that come due after the closing date. And if you check the seller box or you leave it blank, the seller shall pay the, if the seller's responsible, we check the seller box or we left it blank, the seller is obligated to pay the applicable special assessment in full prior to or at the time of closing, unless the special assessment is not payable in advance because of association requirements. There are some associations that do not permit the special assessment to be paid in advance or in a lump sum, even if it's payable in installments. So if that's the case, middle of this line 99 of the red line, if that's the case, and again, this is where we've checked the seller box, the amount of the special assessment shall be credited from the seller to the buyer at closing, meaning that the buyer is given the credit so that the buyer can continue to pay the installments as they occur. It goes on to say, and then we get into the third sentence, which is not a change from what we had before. But if there are pending liens or pending special assessments, those are something other than something that's been fully and finally approved and all the votes have taken place, which are not seller's obligation, meaning they weren't approved on or before the effective date. And if they weren't disclosed in writing to the buyer by the seller prior to or concurrent with the execution of the contract, and the amount of those pending special assessments exceed 1% of the purchase price, the buyer, just like before, still has the right to terminate the contract unless the seller agrees in writing to pay the amount or the portion of that pending lien or special assessment which exceeds 1% of the purchase price. That's not a change. The change is the middle sentence, but this makes paragraph 6 and how you deal with special assessments a little more complicated, and gives you the choice to identify who pays for assessments levied prior to the effective date, which are payable in installments, and the installments, some of those installments occur after the closing date. So that's what the changes to paragraph 6 do. Next,
again, you'll see the date on every page, so you know you're in the right contract. 1/1/25.
The next change on line 151 is really just a word change from upon to against. It talks about monetary liens, but the big change here is on lines 153 through 158 of the red line, and this is really more for your closing agents. But it basically gives the buyer the opportunity to object to adverse title matters that arise prior to the closing date, but after the effective date. Before that, there wasn't any language in the contract to specifically deal with those newly arising title defects. And I'll leave that at that. That's really going to be more for your title agents and your closing agents.
I will say this about this provision. I've already had it come up where an association had a notice of commencement filed after the contract was signed. And what I will say about this is it does give a new 30-day clearance period to deal with the new title defect. So you may get an extension of closing that you didn't plan on, that your seller is going to be allowed to do. So if you've got a financed transaction, be aware that you may have an extension on your hands that you can't get around if you've got a new title defect.
Right. We just had that come up in a transaction between our offices this week.
Yeah, that's right. You were on the other side of it. That's right.
That's right. Right. The next change is again a small change on lines 160 and 160 or 162 and 161 of the red line. The seller, the survey that the seller is obligated to furnish to the buyer if they have it, that only relates now to surveys which are certified to the seller. If the seller has some 25-year-old survey that is certified not to the seller, but maybe to an owner 3 owners ago, that's not something that they're required to provide. And then the other change on lines 171 to 172 of the red line talks about survey objections. And remember, under this contract, a survey objection is treated just like a title objection. And so when the survey objection is properly raised, it creates what's called the clearance period, which is a 30-day period under the contract for the seller to correct or to cure that defect. And this simply clarifies that that 30-day clearance period begins on the date that the buyer or buyer's attorney delivers the survey objections to the seller. Again, we worked through those kinds of issues before, but they really weren't specified in the contract. The next change, line 218 of the red line, and Sam's going to talk about this a little bit later, is another form that is now required by the legislature called a flood disclosure. It is required to be executed in connection with all contracts, not just condominiums, but all Florida contracts. And we'll talk about that. It's a fairly easy form. And then on line 221 of the red line.
Spelling error. That was a spelling error in 221.
Yep. Yep. Just correction of a spelling error. And then moving on, just to clarify, when we're talking about elevated radon, we're talking about the average level of radon. If you look at a radon test, as you all know, it gives you the radon level at a bunch of different times, usually every hour or every half hour during the period during which it's tested, and you get your radon reading from that. The radon reading that comes from that is the average level, but again, this just clarifies it in the contract. Moving on, these
are grammatical.
Yeah, these are all grammatical until you get to page 7.
Well, we have this.
Yeah, that's yep, you're on page 7, and this is something new. This is in the portion of the contract that identifies cosmetic conditions. Now, if you'll remember, if you check box A on this, or box A in paragraph 8 of this contract, which gives you on the residential improved property contract, which gives you the right to go through the inspection process, to do a buyer's election, and for the seller to respond to it. Of course, a big part of that is that the buyer does not have the right to ask for remedial action or a credit for anything that is a cosmetic condition. And we have added, Legal Resources Committee has added to the contract that sunken or uneven pavers are a cosmetic condition under the contract. And then this was really just a more of a, and this is in the risk of loss provision, really a lot of grammatical cleanup.
Yeah, this is primarily grammatical to clarify the casualty included any loss or damage to the property at seller's expense. And it was
Right.
unclear before. And the one thing we did do, I'll point out, We created a new standard D3. Used to be D2E. So now you see D3. So the rest of this is just numbering to clarify for that.
Right.
This is your next major change.
Right. And D3 is really the risk of loss and provisions that relate to casualty loss or a hurricane. Obviously, we lean on those provisions when we encounter hurricanes and such. And so there's a lot of just sort of cleanup, grammatical cleanup there. The next change is in standard E, and this is also going to be cross-referenced when we get into standard J on the next page. There's a new standard E14. This is stuff that these are things that the seller has to provide. And we've added that the seller is required to provide all current information and property management company contact information to the buyer, as well as any required application forms and all statutorily required association documents. The key there is, there's often difficulty in figuring out for the buyer to figure out where he gets his application or who the management company is, the buyer finding that out. Of course, it is the seller who's in a better position to have that information and to know that information. And here it clarifies that the seller is required to provide that information to the buyer. And again, we'll touch on that again when we get to the change on the next page of the contract. The next one is sort of one hand gives and the other takes away. Paragraph I used to be a much longer paragraph in the NABOR contract. It was the condominium resale disclosure. That's all been, so it got short. That portion shortening it here shortens the contract. Of course, now that we have this 3-page addendum to sales contract condominium that Sam went over before, you have to add that in. But it does state that buyers should not execute this contract until buyer has received and read the addendum to sales contract condominium. Again, the penalty, as we mentioned before, that if that addendum to sales contract condominium is not provided, then the buyer, but not the seller, only the buyer, has the right to terminate the contract for any or no reason prior to closing. So that refers to that. And then in standard J, there are 2 changes. The big one is the one in the second sentence on lines 469 and 470 of the red line. And it the contract previously said that the buyer had to make application to the association no later than 10 days after the effective date of the contract. And the penalty, if they didn't do that, was that if the association didn't give them approval, the buyer's right to terminate was conditioned upon the buyer having made that application within 10 days after the effective date. Now, given that there is a requirement for the seller to provide the association and management company contact information as well as the application, that 10 days now runs from the date that the buyer receives the applicable association application forms from seller. As a listing agent, you want to make sure that you and your seller are providing those right out of the gate. Once you certainly no later than the day after or the day that you get an effective contract. But again, that 10-day time period for the buyer to apply runs from the date that the buyer receives that information and really receives the application forms from the seller. The second change is really more for closing agents, and that's on line 477. It used to be the NABOR contract until now said that the seller had to provide the association estoppels to the buyer no later than 15 days prior to the closing date. Now that is 5 days prior to the closing date. Usually the estoppel information are one of the last things that gets input onto the closing statement. And this just really kind of reflects the reality of how long it takes to get association estoppel information. But that's really going to be more for your lawyers or your title companies who are closing your transactions. And then I mentioned earlier a change in paragraph 3 that talked about possession and access to the property occurs at closing. This new paragraph, section R17, is really designed. I think it's more of a common sense provision, but at least now there is something in the contract that particularly a listing agent can point to. You know, at closing, of course, there's a lot of things happening, including the wire transferring usually of the seller's net proceeds. And of course, once as a closing agent, once I hit send or once Sam hits send on a wire, it doesn't arrive in the buyer's account the next second later. It takes some time for the bank to process it. And then once it gets to the seller's bank, then it might or might not take some time for it to appear, for example, online on their website. And you would see the situation where sellers would say, well, I know we've closed, but the money, you know, my bank is not telling me that that money is in my account. And so therefore, I, as the seller, am not going to give up the keys, or I'm not going to vacate the property. This is designed to eliminate any confusion about that. And so the new sentence clarifies that the timing of the seller's receipt of the seller's net proceeds is not a prerequisite to the seller's obligation to vacate the property and give access and possession to the buyer once the closing agent has confirmed in writing that the closing agent has initiated the disbursement of the seller's proceeds and officially declared the transaction closed. So when you get that email from or writing from me or from Sam or from another closing agent that says we're closed, we've initiated the disbursement of the seller's proceeds, and the transaction is closed, at that point, the seller's required to be out. The buyer gets keys, access, and possession of the property. And hopefully, those kinds of issues and disputes, Sam, I'm sure you see them too, come up, and we all do these things, hundreds and thousands of times a year, but our buyers and sellers might do them once a decade. And so they get nervous about their money, and this hopefully will help to address that issue. The next change is that really at the bottom where it indicates the 4 additional addenda that have been added. Again, if you want to use one of the NABOR contract addenda or amend one of the addenda, what you're going to do is you're going to check the box and then complete and attach the appropriate document. So the one for allergenic molds, which we'll talk about in a bit, there's a box for that. There are now boxes for compensation and concessions, as well as the checkbox for the condominium addendum.
Kevin, do you want to mention the case about fully executed and attached here too? Even though
yeah, again, the key here is that if you have the addendum but don't check the box and don't otherwise reference the addendum in the contract, that addendum's not a part of the contract. And according to this, if you check the box but don't attach the addendum and have it completed, then the addendum's not a part of the contract. You've got to now both check the box and check the addendum. And that might mean that maybe the box is checked because the offer wants to include an appraisal contingency addendum, for instance, like on line 625, but the seller counters that that's not going to be included. Then you've got to, among other things, scratch out that what was checked and essentially uncheck it as part of the counter.
And then just one admonishment that this is not entirely new, but all NABOR forms now refer to buyer's broker, buyer licensee, buyer's brokerage, no more listing or no more selling or cooperating agents.
Right. And those are the changes to the NABOR sales contract. Now, we've done this on the residential improved property contract, but the same changes appear in the vacant land contract and in the as-is version of the contract,
Right.
where common sense dictates that they would apply. Obviously, we're not talking about adding the solar panels if we're talking about a vacant land contract. We're not talking about inspection items if we're talking defective inspection items if we're talking about an as-is contract. But you will see these changes tracked on the as-is and the vacant land contracts. Again, the current versions of those are all labeled 1/1 of 25. And Sam, unless you have something to add, I'll turn it over to you for the flood insurance disclosure.
Yep, flood insurance disclosure. Where did I do with the flood? There it is. Okay, flood insurance disclosure. So, flood insurance disclosure is required for all properties in the state of Florida. It is not a voluntary form. It's not a condominium form or a single family form. All properties in the state of Florida. You must put the property address here at the top. And then you'll see, due to recent amendments to state and federal law, flood insurance premium and homeowner insurance premiums may increase. In some instances, increase substantially over previous premiums, and buyers are not to rely on current premiums paid for insurance as the basis for the buyer's premiums. We admonish the buyer to consult with insurance underwriters and homeowner, get quotes for their insurance prior to entering into the contract. And we note that the insurance may be required for buyers for financing. I'll say in almost all cases, when the buyer is financing, they will be required to have the necessary insurance. So again, the seller has to make disclosures regarding the flood policies of the unit or the home, and that there is a separate potential policy for flood insurance. And then the seller has to make some disclosures. The seller has or has not filed a claim with an insurance provider related to flood damage on the property, including but not limited to a claim with the NFIP, that's the National Flood Insurance Program, that's FEMA. And the seller has or has not received federal assistance for flood damage on the property, again from FEMA. And then we define flooding as the partial or complete inundation of the property caused by overflow of water, unusual or rapid accumulation of runoff, or sustained periods of standing water resulting from rainfall. So you have two disclosures really that you have to make as a seller related to flood, again, for every single property in the state of Florida that you sell. So this as a best practice should be filled out by the seller. Check with your broker. I assume most brokers do not want realtors filling these forms out, making disclosures on behalf of the seller. But again, check with your broker. And then as a best practice, put this in the MLS so that signed by the seller so that the buyer can countersign and you'll be in contract. And note that if you do that and a hurricane comes through, double check your disclosure to make sure it's still true. Okay. The next form we're going to talk about is the addendum to sales contract, allergenic mold. Kevin, you want to take this one?
Sure, absolutely. This is the product.
And I'll say, I'm going to interrupt Kevin real fast. Kevin drafted this, and it's an excellent form, and I think we're going to see a lot of use out of it. So thank you, Kevin, for that.
No, my pleasure. So under the base NABOR contract, if assuming we're checking box A in paragraph 8 of the residential improved property contract, the way, and we don't use an addendum like this addendum, the buyer has the right to treat as a defective inspection item the presence of elevated levels of either toxic or pathogenic molds. However, the contract specifically provides that allergenic molds or Penicillium aspergillus, which is, and I'm not a mold scientist, but I've always kind of heard that referred to as the ordinary Florida plant mold that's everywhere. You don't have a right as a buyer to treat elevated allergenic molds or elevated Penicillium aspergillus as a defective inspection item. However, we do have buyers for whom even those allergenic molds or Penicillium aspergillus is problematic. So based on some demand or requests from the membership, there is now this new addendum called Addendum to Sales Contract Allergenic Molds. Of course, it is not to be used with the as-is sales contract, only for the residential improved property contract. And what it says is that provided that paragraph 8A is applicable, meaning you've checked box A on paragraph 8 of the contract, and except as the seller may have disclosed upfront to the buyer, the presence of elevated levels of Penicillium aspergillus or allergenic molds, if you use this addendum, is considered now or would be considered a defective inspection item under the contract. This is obviously a provision that protects buyers. It may or may not weaken or be perceived as weakening the offer, because if I would say in a much larger percentage of properties, I don't know that it's half, but it might be if you got 100 homes with mold tests, you might get 30 or 40 or 50 of them that might be perfect otherwise in terms of mold, but might have this elevated level of allergenic mold. We'll see how that plays out, but this allows those allergenic or molds or Penicillium aspergillus to be treated as a defective inspection item. One thing, though, I do want to point out, and this is true whether we use this addendum or we don't, under the contract, when we're talking about mold, that elevated level of mold, what you're doing is to know whether it's elevated or not, what they do is they do a comparison between the reading in the home and the reading outside the home. And it's elevated if the level of mold is higher inside the home than outside. But the contract, and this is in it's in lines 262 and 263 of the red line form of contract, that establishes that the mold determination or the mold, the testing for it has to be either by air, surface, dust, and or other accepted industry sampling performed by a qualified indoor air quality inspector for the presence of those molds. The important thing about that is, if you get a garden variety home inspection and the home inspection doesn't include a separate mold test, but there are pictures of mold or somebody finds mold behind, on a wall or in a corner, those pictures of the mold don't establish anything, don't mean anything. If you want to be able to or preserve your right to object to the presence of toxic or pathogenic mold without using this addendum, or with allergenic mold or Penicillium aspergillus, if you use this addendum, that still has to be established by air, surface, dust, or other sampling performed by an indoor air quality inspector for the presence of those molds. And again, the level's got to be greater on the inside of the home as compared to the outside of the home. But I agree with you, Sam. I think we're going to see a lot of use of this. I don't know that it's something I would use in every transaction, but some probably will. But certainly if you've got a buyer who might be immunocompromised or mentions, that they have, allergies or something like that,
Yeah.
you're going to see this used more often.
Yeah, I think it's the realtors should ask their buyers if they do have any issues. I mean, the reality is in Southwest Florida, we have allergenic molds. And if you've got a problem with it, then we need to talk about it as, realtor to customer.
Mm-hmm.
And then of course the buyer and seller sign, typical. The last form we're going to discuss today is the addendum to sales contract cooperative. I just want to mention quickly on this form, not much has changed except that if you are selling a cooperative now, the seller has the same obligations. If I can get my mouse to work.
There you go.
As they do for a condominium, to notify buyers whether they have a milestone inspection report, a structural integrity reserve study, or a turnover inspection report after July 1 of 2023, and whether or not those required reports are done. And again, as we discussed earlier, it's the same process as you would for a condominium. So, and there are some additional, again, disclosures and related to that. We don't have too many co-ops in Naples, but to the extent that we have a co-op, you have a 3-day right to 3-day right to void the contract by the buyer if the proper documents are not provided.
And these just track, sorry to interrupt. These really just track the same language that's in the that you'll see in the condominium addendum.
Yeah, and all this is a cut and paste from Florida statute. So it really is quite comprehensive and confusing. And there is a glitch in the statute, and we're working on getting that fixed with the Florida legislature, Florida realtors, Florida bar, and everybody else that noticed it. With that, I'll say thank you for your time and attention today. And if you have any questions, feel free to reach out to NABOR. They will direct you to one of the many attorneys who will volunteer their time to help explain these forms. And look forward to seeing you around town.
Thank you all very much. Have a happy and productive season. Thank you.